16773 in the matter of Uche Wakama.
May it please the court, the Disciplinary Administrator's Office appears through Stan Hazlitt and Deborah Hughes. Ms. Hughes and I presented this matter to the disciplinary panel in this case in July of 2016. I suspect that the first matter I should address is the fact that the respondent did not appear today, and I'm sure the court's aware that last night at 6 o'clock the respondent filed a notice of absence for the show cause hearing, which obviously means he knew about this show cause hearing, so notice is not an issue here. I would like to impress upon the court that there's nothing stated in this notice filed by the respondent explaining to you why he's not here today, which I think is significant. I suspect, although I'm not asking you to do this, that you could hold him in contempt for not being here today. I'm not, again, not asking you to do that, but what I would ask you to do is certainly take it into consideration in whether you decide to temporarily suspend him. The matter's on the docket as a result of our request to temporarily suspend Mr. Wakama from the practice of law. The underlying disciplinary case in this matter, just to kind of give you a summary of the findings of misconduct made by the panel, there were allegations of unreasonable fees, failure to return fees, failure to account for fees, dishonest conduct in his practice, dishonest conduct before the panel, failure to cooperate in the disciplinary process, extensive trust account violations on the part of the respondent. We have numerous trust account records from the respondent, which were provided to us after some extensive effort. To give you a status update of the case itself, the matter was docketed before this court on November 7th of 2016. Exceptions were filed by the respondent on December 6th of 2016, and his brief was due on January 17th of this year. And he filed a request for an extension of time till February 3rd of 2017. And late yesterday, we filed a pleading in which we did not oppose granting him additional time until February 3rd of 2016. And again, in his notice of absence for show cause hearing, he again requested additional time to file his brief, and we don't oppose the request till February 3rd of 2017 to file his brief. It's our belief that if he does file his brief in a timely fashion, that we would have 30 days from February 3rd to file our brief, which we would hope that we could accomplish. Doubt that the matter could get on the docket before the summer recess. Probably would not be heard till September of 2017. And I think that's important information in your determination of whether you should temporarily suspend him or not, because I think we can get the matter before the court pretty quickly. This matter is before the court as a result of a 5-day disciplinary hearing that occurred in July 25th till July 29th. After that hearing, the panel unanimously recommended that the respondent be disbarred from the practice of law. In its report, the panel cited 4 ABA standards which suggested that the respondent should be disbarred from the practice of law. They also recommended in the panel report that our office file this motion for temporary suspension, but I want to make clear to the court that regardless of that recommendation, we had intended to do so, but the panel obviously felt that this should occur as well. In the panel report, the panel explained to the court why it was that they requested that we file a motion for temporary suspension. They pointed out that the respondent repeatedly in their findings in his practice and before the panel had engaged in dishonest conduct. They noted that the respondent, in spite of his protests that he did not do so, continued to practice in the state courts in Texas. And my reading on that was that that it would be nice for the residents and citizens of Texas to have some indication from Kansas, which is the only jurisdiction in which he's really licensed, state jurisdiction in which he's licensed to practice in the United States, from our court that he cannot practice law.
Could you clarify something? Just, I don't mean to interrupt Mr. Hazlett, your flow here, but is he currently suspended administratively for?
Yes,
And he has, so he's currently suspended,
administrative,
administrative, so he's not supposed to be practicing law.
correct,
Under his Kansas license anyway.
correct.
Correct? And he's applied for reinstatement, has he?
In November of 2016, he made an application for reinstatement. I don't think there's any rule, Supreme Court rule, which would prohibit him from being reinstated, even though this is pending against him. There's nothing stated in the rules. And that's,
Is it still, have we acted, I don't think we have, it's still his request for reinstatement, he submitted it, the money that he,
submitted money,
it needs to be supplied in order for him to do that
Well,
where?
at the time he applied for reinstatement, he had not fulfilled his CLE requirements. So the money he submitted to be reinstated was returned to him.
Okay.
I'm not sure whether he's fulfilled his CLE requirements as I stand here today, but he has not requested reinstatement.
As we speak right now, he's suspended, correct?
Correct.
Okay, you can continue. I just
It's
want
administrative suspension.
It's an administrative suspension. And I was going to conclude by saying part of the reason that we think temporary suspension is necessary is because there's nothing to prohibit him from being reinstated at the time at this time if he fulfills his CLE requirements. The panel was also concerned about the nature of the misconduct in the Jay-Z case, a case in which the respondent accepted a $6,000 retainer to represent Jay-Z in an immigration case. That was accepted. Ultimately, there was $7,500 paid, but the money was accepted in the year 2008. The respondent had not filed any request for relief in this immigration case until as of 2014, when the client, Jay-Z, finally went to a new lawyer who was able to achieve the intended results for Jay-Z, who had had a felony DWI case, had left the country. As it turns out, he was eligible to get his work permit back. The relief that the respondent suggested to Jay-Z would have resulted in Jay-Z having to leave the country for 20 years before he could even apply to get his work permit back. So ultimately, what the panel concluded was that there is danger to any clients that the respondent might try to represent. They also noted that no refund was made of the $7,500 to Jay-Z in spite of a request, and that there was no accounting that was provided by the respondent. Just to clarify his license status in the courts in which he practices, and by the way, every court in which he practices, his ability to do so is dependent on his Kansas license. Again, it's the only jurisdiction in which he is licensed to practice. He was admitted to the state of Kansas bar on September 26th of 2003. He has never practiced in the state of Kansas. On six times since he was admitted to practice in this state, he has been suspended by this court for administrative violations, either CLE requirements or failure to pay attorney registration fees. He is presently suspended in Kansas as of October 16th of 2016 for failure to perform the required CLE requirements. Other courts in which he's licensed to practice, the U.S. District Court of Kansas. His ability to practice in that court was terminated in 2004 for his failure to pay registration fees. The U.S. District Court in the Southern District of Texas his ability to practice there expired on November 17th of 2013. The U.S. Court of Appeals for the Fifth Circuit, his ability to practice there expired on February 6th of 2011. U.S. Immigration Courts, his ability to practice there was suspended on December 15th of 2015 at a time right after he was suspended by this court for the fifth time. Again, all licenses that he has to practice in any other courts are dependent on him being in good standing in this state. Respondent primarily had an immigration practice. The way it stands right now, if you're in good standing in any jurisdiction in this country, you have the ability to practice in any immigration court in this country. So therefore, with the Kansas license, he was able to go to the Southern District of Texas and practice in their immigration courts. What the panel noted, I mean, it makes it very difficult for us to investigate and prosecute a disciplinary complaint against somebody who's 600 miles away. In this case, there was an additional problem of language barriers because many of the folks did not speak English. So that's just for your information. Summary of the findings of misconduct by the panel, real quickly: 6 administrative suspensions since 2003, a lack of cooperation in the disciplinary process. We had requested some tax returns, which he thought was relevant, or we thought was relevant, to determine whether or not he charged an unreasonable fee in one of the cases. We first made a request for that information in January of 2014. He provided some of it, but the last 2 tax returns that we requested, 2008 and 2012, which were the most important ones to us, he did not provide until 3 days into the disciplinary hearing in July of 2016. Multiple instances of findings of dishonest conduct, both in his practice and before the panel. Findings with respect to his trust account, which showed that the respondent had a complete lack of understanding of how to actually properly handle a trust account. Numerous instances of commingling, placing his own money in the trust account, paying for personal expenses, professional expenses. In connection with the respondent's representation of 2 of the complainants in the case, they determined that he charged unreasonable fees, that he made no accounting for those fees when the request was made, and that he made no refund of those fees after the request had been made. And last but certainly not least, the panel found that the respondent entered into a settlement agreement with one of the complainants, Mr. Emo, in which the respondent agreed to pay the complainant money, $450,000, in return for the complainant not cooperating with our office. The panel thought that that was compounded by the fact that the agreement was structured in such a way that the U.S. government would not realize that money had been transferred from the respondent to the complainant in the case. And the reason that couldn't happen is because there is a restitution and forfeiture order for $30 million against this particular defendant, and any money that obviously went to the complainant, who at that time was in prison, would have been confiscated by the government. Why request this order when the respondent was already suspended, Justice Rosen? The first reason I'm asking for that is, as I explained, because I think he could attempt to be reinstated absent some order temporarily suspending him. And under these circumstances, that absolutely should not happen. Reason number 2, which I think is equally important, I think it's important for the public to know that he's not suspended just because of administrative reasons. The public should understand that he is temporarily suspended because of the way in which he practices, which is set out in detail in the final hearing report. It's important for the public to understand that. The last case in which we asked for temporary suspension, which was contested, I don't know that we can say this is contested since he's not here today, but you stated the following in your order, temporarily suspending Charles Ball. Temporary suspension under Supreme Court Rule 203, pending final disposition of a disciplinary complaint, is not for the purpose of punishing a respondent, but to protect clients from injury and loss, and to maintain the integrity and reputation of the legal profession. For that reason, temporary suspension is to be used when the conduct constitutes a serious crime or arises out of the respondent's practice of law. Generally, temporary suspension is warranted if the conduct complained of could result in either indefinite suspension or disbarment. Well, I would argue that it's extremely necessary to protect the public, to have him be temporarily suspended and protect clients. Clearly, given the findings of the panel made in this case, it's necessary, I think, to protect the integrity of the profession. Clearly, the misconduct arises out of his practice of law. I mean, it arises out of his representation of clients. It arises out of his cooperation in the investigation. It arises out of his conduct at the hearing itself, in which the panel found that he misled them on numerous occasions. One last thing I'd like to say. Although this is not in the final hearing report, it's in the record. We were questioning him about what he could or could not do when his license was suspended. And the question posed to him was, so that I make sure I understand this correctly, you acknowledge that you can't appear in immigration court because you are suspended. That's correct, he answered. But is it your belief that you could advise somebody on immigration matters in your office if you don't go to court? Answer, because it's a federal question, yes. It is a federal question, yes. So as of the date of the hearing, he believed that even though he was suspended in Kansas and suspended by the immigration court, that it was permissible for him to counsel with clients in his office regarding immigration matters and take money from them to do so. I just feel like, and I would urge the court to issue an order saying it is not permissible for him to practice law by going to court or by advising clients. And I would ask that the court do that as quickly as possible. And I think it is definitely for the protection of those in Texas and wherever he practices.
Counsel, I had a question about the document that the respondent faxed to us last night at 6 o'clock. Just so I'm clear, your reading of this is the brief that he's referring to is the brief that has been hanging fire for the last few months, is that right?
Well, his brief was not due till January 17th.
But that is the brief that he is referring to, that he wants a deadline set.
Correct.
Any questions? I see none. Thank you, counsel.
Thank you.
That concludes this morning's docket. Court is now